All right, the next case is State versus Lee.
May it please the court. My name is Chris Davenport, and I represent the state of Florida. This is an appeal from a trial court order dismissing an information charging...
Second, how much time do you want for rebuttal?
Oh, I'm sorry, 2 minutes.
Okay. All right.
This is an appeal from a trial court order dismissing an information charging the defendant with soliciting a child and traveling to meet the child for sex. This is a de novo review because it is a motion to dismiss, and of course all facts and inferences need to be construed in favor of the state. The legal issue here is whether a defendant can be charged with soliciting or seducing a child when the conversation takes place through an adult instead of directly through the child. The trial court found that...
You're aware that we have this issue on a number of different cases, correct?
Yes, we do.
And is there anything unique about this case that is not contemplated by the other cases that you're familiar with?
Not from a legal perspective, they're all the same, but I think this case does have something that well illustrates. The defendant relied on the fact that in subsection B of this statute, they address conversations with a child. Subsection A discusses soliciting the child. Something I think in this case that well illustrates why A applies to these conversations, even though it was through an adult, not directly with the child. On page 169 of the record, they're texting back and forth about what they're going to do once they meet up. He's speaking to the purported aunt. And the aunt says, "Where do you want her to fondle you? I woke her up and she asked me to ask you that." So I think this clearly illustrates that the statute is applying here when an adult is an intermediary, versus in subsection B, that applies when you're trying to get the consent of the adult, and it's all focused on the adult. For example, if a defendant wanted to tie up and rape a 3-year-old, that would come under B. You'd need to find somebody who had access to a child and physical control over a child. The child willingness to participate in that has nothing to do with it in that situation. That's what subsection B is about. Subsection A is where you're actually trying to seduce the child herself. And the question is whether you can do that without directly talking to it. And here I think that well illustrates that text. You know, some of these kids don't have direct access to the internet, and they have to go through adults. Maybe there's a fun neighbor in the neighborhood where all the kids go and hang out, and he's on the internet. And he says, "Hey, I think this guy is looking for a 12-year-old. You're interested?" And the kid says, "Sure." And so he responds to the ad, and then they carry on a conversation like that. "I asked her, she asked me to ask you that." That's an adult intermediary, and it's the state's position that that does fall under the plain language of the statute, that it doesn't come under B, it comes under A, and that addresses a specific thing.
Let me ask you this. You know, it seems to me that it wouldn't make much sense for the legislature to leave this giant gap of an intermediary given the intent of the statute.
Yes.
But I also understand the opposition's argument that why even have Section B? I mean, I'm not seeing a situation where you could be convicted under B but not A.
You're not seeing a situation?
Well, because really in B, you're just saying that the parent, guardian, or custodian is just, in essence, the intermediary. I mean.
Now, under B, you're seeking the consent of the parent. Under A, you're seducing the child. So I think there is a situation, and again, it's, suppose you want to rape a 12-year-old. You don't want her to be willingly participating. Your fantasy is the unwillingness of a kid. You want her screaming. You would go under B in that situation. You'd seek the consent of a parent or somebody who has physical control over that child, and you'd say, "Tie her up and I'll be over." That wouldn't come under A. You're not seducing the child. You're not soliciting the child. You don't want the child to be seduced. You don't want the child to be willing to engage in this act. You're going for something different, that would come under B, because you're looking for the consent of the parent. And when the state has to prove these cases, it's not always that situation. I mean, sometimes they're just looking for a kid and they're going through the parent. So all the state would have to prove when it's a parent situation or custodian or legal guardian is that they were seeking the consent of that person. It has nothing to do with the willingness of the kid. They're looking for that person to supply them with a
A involves
child.
where the child is willing, and B involves where the child may not be willing?
I'm saying the state has to prove under B that they're seeking the consent of the person who has access to the child. Under A, the state has to prove that they're seducing the child. So if you had somebody who kidnapped a kid and they weren't a guardian or custodian, and they said, I have one tied up, here you go, I would say that that might fall through the cracks. That would be a situation that would fall through the cracks. What doesn't fall through the cracks is this bigger picture of, yeah, I didn't actually talk to the child. What if it's a 5-year-old who can't type on a computer? That would be a huge hole, and there's a whole world of pedophiles out there who are looking for those kids on the internet. They have to go through an adult intermediary or some kind of intermediary because the kid's too young. But they're looking to seduce the child, they're looking to create an opportunity to get to the child, and it would fall under A, and you know, sometimes it would fall under both. But this one doesn't fall under both because it's an aunt. We can't demonstrate that she was the custodian. There's nothing in that transcript of the chats or emails that indicates that she had custody of the child. So we can't go under B. In some situations, they could go under both, but not in this one. We have to go under A. Florida put in B after A came out because they wanted to broaden the reach of the statute. It would be pretty ironic if this court would construe it to narrow the reach of the statute. It would be directly contrary to the legislature's intent to protect children. And I think these federal cases address similar language as what we have in A. They don't have a Part B in the federal statute. But again, I would submit that Part B is a different animal. It actually kind of lowers what we have to prove because you just have to show we're looking for the consent of a certain person. A is the one that is going after the child herself, and A is the one that this kind of conduct falls under. And as the federal courts recognized, it falls under the plain language. You don't have to talk to somebody directly to seduce them. You can go through an intermediary. And it also fully supports the public policy of these statutes, which is to reach these people before they can get to the children. So we would submit as a legal matter that the trial court erred in dismissing this information because it does fall under the plain language and certainly the intent of the statute to allow us to prosecute under this section, even though he never actually talked to the child. He said, she asked me to ask you that. Boy, that's a classic example of an adult intermediary that all of the circuit courts have said falls under their statute, and it falls under ours as well. So we would ask the court to reverse, and I will reserve the remainder of my time. Thank you.
Thank you.
Mr. Pennell, before you get into the substantive argument, you've got another case in January.
I do, Your Honor.
And is the legal argument the same in that case as it is in this case?
Your Honor, I believe it's identical.
Is there any need for an oral argument in that case, then?
I guess the sole need for oral argument, in my opinion, would be that it's a separate panel of judges who may have questions that the 3 judges today don't. So I would like the opportunity to do oral argument so I could answer their questions. But the legal issue is identical. May it please the court, my name is William Pennell, and I represent Michael Lee, the appellee in this case. It's our position that the undisputed evidence before the trial court failed to establish a prima facie case against Mr. Lee on either count of the amended information, which charges a violation of subsection.
What's the hypothetical where you have a child that is too young to communicate? There was just on the news the other day where a guy was arrested for, with some child porn involving a child about a year old. So what do you do in a situation, address this situation where the child's too young to communicate? The state can't bring charges for solicitation then?
No, Your Honor, the legislators addressed that with subsection B. Subsection B is, and it's clear, when you look at A and B addresses communications with an adult, a parent, custodian, or guardian, and that would be the appropriate statute to go under in that situation.
But then aren't you going to be attacking the fact that there was no proof that this was actually a parent, custodian, or guardian? At best, what you have is, I think, an aunt. That would be the extent of the relationship. So at that point, then you're going to be arguing in a motion to dismiss that the state has not proven that custodial relationship, correct?
It would depend on the fact scenario, and I would note, just for the record, this fact scenario is created by law enforcement. This isn't a real scenario. This is an imaginary scenario created by law enforcement who knew the laws. But to answer the court's question, certainly we could challenge that, the defense could challenge that, and it was challenged in this case. The state actually filed a traverse in response to that motion and said that there was a custodial relationship in this case because, quote, the aunt got custody of the child when the mom left the child in a crack house. So it was the state's position below, at least initially, that there was a custodial relationship in this case. And I would point to this court's decision in Vitale, which I was counsel on, where the court found that simply saying, I am the boss of her, as an older sister, was sufficient to establish a custodial relationship. So it's not a high standard for the state to meet, this custodial relationship. So an aunt certainly could have custody of a child temporarily if the child was staying there for the weekend, for the day, was just watching him, or took him to the movies, took him or her to the movies. So I don't think that that's a problem for the state to proceed under B. And the legislator has chosen to limit the situations with the intermediary under B to custodian, parent.
What makes you say that? What are you pointing to that says the legislature intended to limit that?
The amendment of the statute to include B, which says parent, guardian, or custodian. And there's nothing in the plain language of A, and you got to read these together. You know, there's a Latin term that I can't say, but you got to harmonize these two statutes. You got to read them together. It's clear that A is direct communication with a child, and B involves communication with an intermediary. Now, I understand the federal cases, but there is no B under the federal statutes. So it seems clear to me.
But you're reading, where in the statute does it require a direct contact with the child? Where your use of a computer, online service, internet service to seduce, solicit, lure, entice, or attempt to seduce, solicit, lure, entice a child. Where does it say, that it has to be direct?
Well, Your Honor, it doesn't say seduce a child or a parent. It says seduce a child or a person believed to be a child.
Why can't that be done through a third part, through an intermediary?
It can be, and that's what B covers.
Well, why doesn't A cover that?
Because you need to, number one, you need to read them together.
Well, you're reading B to restrict A, where B can theoretically cover something else.
I'm not sure what else B would cover, and I think if the court accepts the state's position, you're rendering B meaningless and surplusage under the Mendenhall case. There's no reason for B if A covers this intermediary situation.
Let me ask you this, if B was not in existence, do you think and you just had A, do you think that language would support the state's interpretation?
I don't, I disagree, but I understand the federal cases would support that argument.
Because B, when, the legislative history behind the enactment of B was, it was their intent to expand and strengthen the statute, and if A would have supported a conviction here, and B, and the legislature intended to strengthen the laws against solicitation of children for sex, wouldn't it be, Ms. Davenport's argument was to be ironic if we were to limit A, if we accepted your argument?
It would be, Your Honor. Again, my position is that A would never covered it. I understand the federal decisions, which aren't binding on the court, would suggest otherwise.
A didn't cover it because it wasn't directly with the child?
Correct.
All right,
Correct.
so you would read A to have required direct contact with the child?
I would, Your Honor.
All right.
I would, Your Honor.
So,
But I think
if you had two 20-year-olds, 19-year-olds, and, one of them says, I'd like to have sex with your 10-year-old sister, and, does this by computer. And the person said, well, I'll check with her and see if that's okay. Be your position that there's been no crime committed.
It would depend if the sister had a custodial authority or...
Let's assume no custodial authority.
Under the statute as written by the legislature today, Your Honor, correct, yes.
So it'd be your view that would not be a criminal act? As long as the 20-year-old was not the custodian?
Your Honor, it might be another criminal act. It might be an attempted lewd or lascivious under 804, but it wouldn't be a criminal act under these statutes. I'm certain I could think of a criminal act that was committed. Again, it's not under these statutes that we're interpreting today. But I want to point to the legislative history because I think that it actually supports the idea that this was added and subsection B was added to address the intermediary situation. The Senate staff analysis says that the addition of persons who are believed to be a child or a child's parent, legal guardian, or custodian as victims makes it clear that a crime is committed even if the perpetrator is actually communicating with an adult. And that's the chapter law that added subsection B. So subsection B was added to address the situation when the defendant is communicating with an intermediary. Additionally, the federal cases that the state relies on heavily all address a situation where the defendant is communicating with the persons that would be covered by B. In the Morrell case from the 11th Circuit, the defendant's communicating with a father. The court says that it would make no sense to not allow conviction with an intermediary because the father presumably exercised control over the 13-year-old girl. That's what B covers. So the federal cases actually support our position. The Lee case from the 11th Circuit says, sexual predators attempt to persuade children to engage in sexual activity through the victim's parents or guardians. And in that case, again, it was the mother that was communicating with. So B is consistent with these federal cases that the legislative intent is to protect children, but it's to protect children through communications with people that have control or authority over these children, which is parents, guardians, and custodians. It may make some policy sense to broaden it, but that's not what the language of these statutes say. And the trial court, this court, shouldn't overstep and read the language into these statutes that doesn't exist. I point to the Stelmach case. Statutes creating and defining crimes cannot be extended by construction or interpretation to punish an act, however wrongful, unless clearly within the intent and terms of the statute. And in that case, they interpreted a statutory section on sexual conduct of a child, and they found that a simulated exhibition of genitals. It was a picture, a child's face on a picture a picture of a child's face on an adult body, and that wasn't sexual conduct of a child. And they said you couldn't read language into the statute. It's the same thing here. There's no language in these statutes when you read them all together, A and B, that lead to the conclusion that A supports an intermediary. B is the right statute to proceed under. The state was free to do so. They chose to amend to subsection A. The state relies on the Colorado case and the federal statutes. Again, neither of those statutes have two statutory subsections which clearly delineate communication with the child in A or communication with an intermediary in B. Additionally, the Colorado statute has a specific section that says the minor does not need to perceive the enticement by the defendant. So that's different than our statute. It has that additional language. So the Colorado case isn't on point and shouldn't be considered as probative here.
So if you have a child who's not old enough to communicate and it, for whatever reason, doesn't fall within the parameter of B, no crime is committed.
Again, there may be some other crime, but not under these statutes, not under the language of these statutes.
So you can never proceed under subsection A, under that hypothetical that Judge Cohen gave you?
No, Your Honor. Because it's clear by adding B that they've laid out a framework. A is for direct communication, and B is for communication through an intermediary. And the legislature's chosen to limit it to custodians, parents, and guardians. They're free to amend that, they're free to expand that. Again, it's not the trial court's job, not this court's job to add language to the statute, but it's clear from the amendment and the staff analysis that was added to make it clear that it could be done through an intermediary through the language of B.
Now, we would agree that just normally, the normal everyday use of the word solicit, you can solicit through an intermediary, right?
Sure, depending on the language, the other language in the statute.
Oh, well, leaving out statutes, just the normal everyday use of the word solicit. People can solicit someone else through an intermediary.
Of course.
Okay.
Of course, but when you read the rest of subsection A, it says solicit a child or a person believed to be a child. So, and then you also have to consider B.
But if the normal use, everyday language of the word solicit includes an intermediary, why don't we read into A, anyone who solicits, including through an intermediary, a child or person believed to be a child?
Because if you do that, Your Honor, then you make B meaningless. There's no point of having B, and you've got to read them together. I agree with your point in a vacuum, but we're not in a vacuum. The statutory construction rules say you got to consider them all together.
That goes back to my original question on A. If you didn't have B, would the state win their argument?
I think there'd be a better argument. Sure, it'd be a closer call, and the federal cases would support the state's position. Again, no, you're not bound by the federal cases, but that would be a better argument for the state for sure. But you can't do that. You have to read them all together. The cases are clear, and when you read them together, it's clear that the Florida legislator, not the federal, not Congress, or not Colorado, the Florida legislator has made a decision to have direct communication in A and communication with an adult intermediary in B under certain circumstances.
Mr. Davenport argued, gave hypothetical that you could have a violation of B and not A, very limited circumstances. Would you agree or disagree?
Can you repeat the question?
Could you have a conviction under B which would not also be a conviction under A? Would that be possible?
Not a conviction under B that would not be under A. Well, to me, it would be anytime it was through an intermediary, it would only be under B and not under A. So yes.
Okay, but accepting her interpretation of A, could you still have a conviction under B and not A? Can you think of any fact pattern? She gave hypotheticals. I'm just asking if you agree or disagree with that.
Conviction under B and not A.
I mean, if A included the term solicit, including through an intermediary, could you have a conviction under B that you didn't have one?
You could probably conceive of some
Bizarre.
hypothetical.
Okay.
But I don't think that's the test. I think the test is we have to apply this language. I don't think that it's the court's job at the trial court level or the appellate level to divine public policy reasons. We might agree that it'd be a good idea that B cover all adults.
But if B
That's not what the
could,
language of the statute says.
but if you accepted the state's interpretation of A, and B could convict under at least one fact scenario that A didn't, then it wouldn't be superfluous.
I'm not sure that's correct, Your Honor. And again, we know what the legislative intent is by reading the statutes.
You don't want to go with the legislative intent. You want to argue something other than that, I think, because the legislative intent was not to narrow the protection of children.
Of course not. But again, to reiterate, I think you need to read them together. I think by the language of the statute, it's clear that they made this delineation, and to apply A to communication with an intermediary is adding language to that statute that doesn't appear there and is inconsistent with B. So for that reason and everything in my brief,
I don't understand how you say that, because you agreed with Judge Evander that that the plain and simple meaning of solicit could include through an intermediary.
in a vacuum, but not with the rest,
Through its common usage.
Right, if you didn't have B, and if you didn't have the rest of subsection A, Your Honor.
If it can include to solicit through an intermediary through its ordinary common usage, then the argument that you're making in terms of B is really a distinct argument. It's not adding words that weren't there. It simply is in trying to interpret B in some fashion that
I disagree.
superfluous.
I disagree, Your Honor. I think when you say the word solicit, of course, you could solicit in various different ways, but you got to read the rest of the statute. It says solicit, lure, entice, or attempt to seduce, solicit, lure, entice a child or another person believed by the person to be a child. It's our position, the plain and ordinary meaning of that is directly with the child. You're soliciting the child. And then you add B, which addresses the situation where there is the intermediary, which I think strengthens that argument, because they've addressed specifically how you do it through an intermediary. And that's what the legislator has said, and when you read everything together, it's not appropriate to bring a charge without direct communication with the child under A, and we'd ask the court to affirm the decision of the trial court.
Thank you.
Thank you.
Thank you.
Mr. Davenport, as you walk up here, I'd like you to give me your best example, your best hypothetical of a scenario where, accepting the state's interpretation of A, that there could be a scenario where you could get a conviction under B, but not A.
Well, I would say it's because of the different ways those subsections are phrased, and again, the plain language,
Well,
A
I'm saying,
says seduce a
give
child.
me one scenario
Okay?
where, accepting your interpretation of A,
Where the
that someone
entire
could be convicted under
conversation-
B, but it would not qualify under A for conviction.
Where the entire conversation is, I really want to rape a kid, not have sex with a kid, not the kids are sexy and want this. I want to rape a 6-month-old. Do you have one? Well, yes, I do. Well, how about if you come over and bring him, and, I'll do you first, and it'll be really fun, and we'll have some wine and have a party, and then later on, we'll tie that kid up and I'll do him. Will you agree to bring the kid to me? Yes, I will. That's not seducing the kid in any way. It'd be hard to seduce an infant, I would submit, but that's not seducing the kid.
Well, you're
That is
saying if that was a
soliciting
parent
a
on B.
parent. That's a parent. Soliciting a parent to consent to the participation of the child in any act. I would say that would be a clear situation where it would have to be a custodian to do that, because they'd have to have the control over the infant to bring it.
If any
And it has nothing to do with...
What other scenario could you...
I would say any scenario where they focus where they focus exclusively on the adult, and not, the A is directed to seducing the child. It's interesting that A has the word seduce in it and B does not. B focuses on luring or enticing the parent to consent to the participation of the child, versus A is seducing, soliciting, luring the child herself. So I would say in a situation where...
You lure a child and not have the child's consent?
Well, legally, they can't consent, so let's use the word willingness.
You're using the word consent. So
Yes, okay, so let me switch that to willingness to go away from, because of course the child can't consent. B is luring the parent, and A is luring the child. That's the difference between the two subsections.
Well, then, under your argument, if someone contacted a parent with a 1-year-old and said, can you bring the 1-year-old along for sex, that would be a conviction, that could be a charge under B, but not A.
Yes,
But that would also mean that if it was someone contacting the 20-year-old non-custodian older brother, that would not be a crime.
if we
Say,
can demonstrate...
Bring your 1-year-old sibling along with you.
In that situation, I would say the legal issue would be whether or not we could demonstrate they were a custodian. And if, in that kind of a conversation, bring the infant to me for this participation in this act, I would submit we could demonstrate that it was a custodian in that situation, because you'd have to have a situation where you're focusing on getting that person to have the child participate versus focusing on getting the child to participate.
You cannot establish that the 20-year-old
If we could not
sibling is a
establish
custodian.
that, I think that would be a tough sell for the state, yeah. I do, because it wouldn't be soliciting the child. I mean, hopefully, in that situation, we'd have conversation there that we could point to and say, yeah, they were soliciting the child too. But if there was nothing like that, then it'd come under B, and we'd have to demonstrate custodian, yeah.
Friend's sister. We want you to bring your friend's sister along.
Right, that would be hard to demonstrate custodial authority, but, hopefully if you can bring her there unwillingly, that I would assume would argue that that's custodial authority for that brief period of time. Now, whether or not that would be successful is a different issue, not before the court, but it illustrates, B is about getting the consent of this person who has access to the child, A is about seducing the child. And defense counsel said we can't read language into the statute. He's reading direct solicitation into that statute. If that's what the legislature wanted to do, they could have stuck the word directly in there. It would have been very easy. That clearly was not the legislature's intent, and under that situation, if they said directly seduce or through direct communication or contact, we wouldn't have a leg to stand on here. That's not in there. He's reading that language into Part A. That's not there. I would submit Part B is focused on a different situation. It's different elements. We have to show we were soliciting consent of the adult. The consent of the child or the willingness of the child has nothing to do with B. The willingness of the child comes under A, and this is a great illustration of how A works. I woke her up and she asked me to ask you where you want her to fondle her. I mean, that's clearly through an intermediary. Under the plain language of solicit and seduce, you can do it through someone else. Defense counsel agreed with that. Let me just address, he said that this is an imaginary scenario where if the state had done it better, she would have said, and I'm the boss of her for the weekend, which is sufficient under Vitale. That's fine for an imaginary scenario where law enforcement can direct the conversation. This doesn't just happen in imaginary scenarios. This happens in real conversations with real kids and real adults, putting those kids out there. So we can't guide those conversations to squeeze it under B. It has to come under A. There's a big hole in the statute if this court would read language in requiring direct communication. And we would submit the better policy and the plain language of the statute. You should follow the federal courts and read it as they have in the similar federal statute.
Thank you both.
Thank you.